As all of you know, I am not the only attorney who posts videos out there speaking about different parts of immigration law. I know that there's a lot of videos out there on TikTok, on Instagram, on Facebook, YouTube, and they discuss different aspects of immigration law. Most of them are very helpful as they come from qualified immigration attorneys. But there are also a lot of mistakes out there. A lot of times I hear videos about things that are just flat out wrong. Either they're wrong because they're not understood by the attorney, or they're wrong because it's not the whole picture. Not the whole thing is explained to them. So I think it's very important that you be careful when you're watching an attorney's video on a TikTok or in any of the platforms, and they tell you different things. I think it's a good idea to verify it and to make sure that what they are telling you is correct, because it is not always correct. I thought it would be useful for today to have a top 5 mistakes of what attorneys say online in their videos that are just plain out false or misleading. The first one is something that I've discussed very often, that I have my own YouTube video on, is the fact that a lot of attorneys tell you if you're in asylum, then you're not able to apply for anything else. That's false. That's just wrong. We have had many clients who were in asylum status, who were actually waiting for their asylum interview, and they came to us and we did an EB application for them, and we did an adjustment of status, and then they got their green card. That is something that is obviously much more complicated than a few seconds, but in general, you can contact us and we'll let you know if you qualify to do an adjustment of status and get a green card while you are waiting for your visa interview. But the long story short is that if you're in asylum status, it doesn't mean that you cannot apply for something else. Another one that's closely tied to it is that if you're in court proceedings, if you're in removal proceedings, in immigration court, that the only thing you can apply for is asylum relief. That is also not true. I have another video on this exact topic, but in general, if you're in asylum court, it does not mean that asylum is the only thing that you are able to obtain. If you're in immigration court, you can also sometimes petition for adjustment of status based on an EB that you prevailed in, based on a marriage, an I-130, and there are also other bases. The immigration judge has all the rights to do an adjustment of status, just like an immigration office would. The third point that I often hear from my clients is that they saw a video and the lawyer told them, oh, if you're out of status, if you came in here on an asylum status, then if you want to get married and get a green card, you have to leave the country and then apply, get an approval overseas, and then come in. That is also not always true. There are many instances where even if you're here illegally, even if you are out of status, you have a right to apply for a waiver of that illegality. It's a waiver of the restriction of your right to do an adjustment of status. So again, if you have a marriage to a US citizen, not a green card holder, but a US citizen, and you are here out of status, you can contact us and we will let you know whether you qualify to do a waiver and get your green card without leaving the country while you are still in the US. Next is something that I hear often from some attorneys out there who put videos about the EB, and they say, look, if your EB petition, your I-140 is denied, then you will have to leave the country, otherwise you will be deported. It's not necessarily wrong, but it's also a very limited and misleading way of looking at it. True, if your I-140 is denied and you don't do anything about it, you have to leave the country because you will be out of status. However, there are a lot of options that you have available to you if you have a denial. Options such as appeal, options such as filing another application, or the option of a writ of mandamus, which is when you go to federal court, and something that I've discussed very often in other videos. The last thing that I wanted to clarify is that I've seen videos where people say, hey, the EB1 or EB2 or EB3, they're closed. And what they're really talking about, again, there is that it's not that it's closed, but it's that it's subject to visa retrogression. Currently, the EB2 visas are on a visa retrogression of about 1 year. For EB3s, it could be 1 year or it could be more depending on the initial action or the final action. However, none of those visas are closed. You have a right to apply for the EB2 today. Currently, you have a right to apply for the EB3, and you will get an approval or a denial. You'll get adjudicated. Now, the adjustment of status that is based on that approval will have to get filed only when the visa becomes current. So recently, the EB2 jumped for about 6 months. It went from February to August of 2023, meaning that if you filed your I-140 before August of 2023, you have a right now to apply for a 485. Again, The situation is not as simple as they may make it sound, and you may have different rights. So if you're in a situation with any of the above, you can contact us and we can discuss with you what your real options are.